All right. Superior Court of Fulton County, Atlanta Judicial Circuit is non-session. The Honorable Judge McAfee presiding. Court will now come to order.
Thank you all. Please be seated. Roberts. You go. All right. We'll go on the record then. This is civil action number 2020CV339937. Wade Grunberg Wilson and Wade Grunberg Wilson LLC versus Mr. Wood PC. And I believe those are the only remaining defendants, but at least those are the ones who are here today. If we could start with having counsel of the parties just identify themselves for the record.
Plaintiff, Your Honor, Drew Beal, Linda Brown for the plaintiffs, Michael Gossett, bar office also, and the three felons, Jonathan Grunberg, Nicole Wade, and Taylor.
All right. And Mr. Beal, are all three counsel anticipating and participating in argument or evidence to some degree, or should I just be addressing you primarily?
It'll be both me and Ms. Brown.
All right.
Gossett is, works with us, but is not counsel.
All right. And for the record, who do we have for our defendants here today?
John Exum, and counsel for defendant Ellen Wood, and Ibrahim Reyes via Zoom for Ellen Wood as well. And Mr. I need to confirm that he's on Zoom.
Yeah, we can make sure we got him on there.
So it's Lynn Wood, Your Honor, and
Yes, sir.
pro se.
All right. Well, welcome back, everyone. Let's figure out this bit of housekeeping first. We provided the Zoom link. I'm not seeing Mr. Reyes in our waiting room, so I don't know if someone can give him a shout, maybe give him a call, and we can make sure he is attempting to log in. And then again, just so I'm kind of clear logistically, who do we intend to be taking point for the defendants during argument and cross if necessary?
It had been planned, Your Honor. Ibrahim Reyes was prepared to handle the hearing, and his flight got canceled. I assume due to weather.
So I mentioned, and I heard that this morning, and we can talk through it. I think the first request was for a continuance, and my reaction to that is that we had set this date at the request of Mr. Reyes, and we had tried an earlier date, but we set a second one for him. I understand things come up, but I'm willing to make every accommodation for him that we can, and hopefully we can do that through Zoom. And if there's, some other reason why you think, I don't know if you're renewing the request for a continuance, but my initial reaction is that it's hard enough to get everyone in a room together to hear this, and I think this is the kind of motion that deserves to be heard in a timely fashion. So I don't see our next opportunity to request it or to continue it to, and I think we'd be able to accommodate them through Zoom.
Well, I pray that you will, because he's the lawyer prepared to handle it.
So there's no question we're going to wait till he's on and he's set up.
Well,
My
we
point
would-
is,
we
and
would-
I've had folks through Zoom direct and cross-examine witnesses and make arguments and
Yes.
exhibits and that sort of thing. So if there's other things you need to do to accommodate him remotely because of this unforeseen circumstance, I'm all ears. If you need to pause and call him or consult with him or things like that, we can figure that out. I just want to make sure we've addressed all this on the front end, kind of as a matter of housekeeping.
Well, I believe he was going to renew the motion for a rescheduling.
Okay.
The date was not picked by him. There were several to choose from, and he was available on this date. I'm set along with the plaintiffs on trial Wednesday in federal court.
Do we have any idea how long that trial is expected to last?
I hope not long. I need to get back home. We're going to have 25 inches of rain today.
Was there a pretrial conference order of some sort?
About a week.
Okay.
Wednesday to Wednesday.
All right.
So Ibrahim says no. It says waiting for host to start meeting.
All right. Well, let's just see if we'll just go off the record for a moment so we can talk about logistics and make sure we get him in before we keep it up. What do you got?
Make sure he knows there's a second link that was sent to him. He might be trying to enter through the first one. There's a more recent one that was sent in the afternoon.
Can you resend this one? Sure. Thank you.
This one.
Ms. Sue, what time did you send the second link?
I sent it before the hearing.
Within the last hour?
Yeah,
I don't believe
and I
I,
just resent it.
okay. I'm not seeing it come up.
I sent it twice now. He's on. Okay.
I mean, we just got out to the screen here. Right. Boyd will do that. There we go. All right, let's go back on the record. Mr. Reyes, can you hear us all right?
Good afternoon, Judge. Thank you. Yes.
All right, I think we can hear you as well. Unless there are any complaints from council, we can adjust the volume. So we had just gone on the record and gotten the parties to make their appearance, and your client, Mr. Wood, indicated that you might wish to make a motion of some kind before we would move forward. And happy to let you make your point here. What I was saying in response, though, is certainly my sympathies for the canceled flight, but willing to make every accommodation for you today in order to try and hold to this hearing today so we can
Thank you.
move forward.
I wanted to renew our request to continue the hearing. The reasons being that this is prejudicial to my client, to Mr. Wood. We should all be under the same set of circumstances. I understand that it is my flight that was canceled and not everybody else's flight, but we didn't plan it this way. And there's no real emergency that needs to be heard right now. Everybody could be accommodated, so this hearing takes place when everybody's available and Mr. Wood is not prejudiced. That's our request, Your Honor.
All right. Well, I can tell you that if you're the one making arguments, it's not like I'm going to find you less persuasive because you're doing this through a video. And if you're cross-examining, I'm not going to find you're questions or responses any less powerful remotely. And if we need to pause so you can talk to your client or co-counsel, I'm willing to do that too. So when you say you're prejudiced, can you give me anything more specific about why you think appearing remotely, which I will tell you, I don't find that to be any fault of your own or anything like that. I know these things happen. But what is it by the way of exact prejudice that you're worried about here?
Your Honor, I'm not even sitting next to Mr. Wood, where I normally sit, where I can confer with him regarding the arguments that we make. He is my co-counsel. I'm on my own, John Exum is on his own, and Lynn Wood is on his own, and there's a remedy to this. And I hope that the court finds that there's a remedy to this and acknowledges it and allows it.
Sure, and that's what I'm trying to do is to fashion that remedy. So if the concern is maybe instant communication, is that something where we could set up a text stream? I don't know if you've got, I mean, text may be a bit of a delay, but if there's some kind of live chat feature, I know there's all sorts of those through Gmail or whatever other means where you could stay in instant communication. And if not, again, if we need to pause at any point so you can consult and confer on notes, I'm happy to do that too. But the reason I'm wanting to push forward is, like I mentioned before, we only have limited time. I still got criminal cases scheduled for next week and the week following. I've got another batch of civil cases in the backup, and we've set aside the whole afternoon. And I'd like to stick to this if we can. So is there anything else, Mr. Reyes? Is there any other way we can accommodate you?
No, sir. A hearing in a live hearing would be the accommodation that would best suit Mr. Wood. Everybody would have a fair setting, the same circumstances. We don't have that now. So that's my gripe with this whole process.
All right. And Mr. Wood.
Might add some volume to Ibrahim's. We don't have a mechanism in place with respect to exhibits that are going to be put in, how he's going to know, how he's going to get them. There are several motions pending, some of which have been pending for a long time. 2 weeks delay is not unreasonable. It's an afternoon. We could accommodate and do it on a Saturday if the court wanted. But I'm sitting here without my lawyer.
We've got one of them.
I have John Exum, yes, but he's not lead counsel. He's been practicing, how long, John?
A little over a year.
A little over a year, was learning quickly. I relied 100% on Mr. Reyes to prepare for and handle this hearing. And given the potential to have the unlevel playing field, I don't see how it is harmful to delay this for a couple of weeks so that we can all be here together and I can be adequately and effectively and efficiently represented by my lead counsel.
Mr. Reyes, when are you planning on coming on, try to get here? Are you handling this federal case that's happening Wednesday?
Your Honor, I am not trying the Wednesday case.
Okay. Mr. Beal, any thoughts on your end?
Real briefly, there is a remedy here. Let's get a Saturday plane ticket. Get a Sunday plane ticket. Be professional. This was set as an accommodation to Mr. Reyes because he couldn't make the earlier because he resides in Florida. This is deliberate.
Well, I don't know if I'll go that. I mean, deliberate neglect, perhaps, but I don't think it caused his plane to be canceled.
Well, if you live in Miami and you don't know that a tropical storm is coming up, I think that's almost impossible. That's like being in Atlanta and saying, wow, traffic, where'd that come from? It's the same thing. There have been 4 motions to delay the federal trial. The posts speak for themselves. There's not going to be a lot of testimony and shenanigans today. We're going to put up the posts. Ms. Brown is going to explain them. They're all in the motion. The motion really speaks for itself. And this isn't going to stop these attacks until Your Honor makes it stop. Your Honor will make it stop. And another 2 weeks means another 2 weeks of my clients being pedophiles and being attacked. And that's where the prejudice is.
All right.
That issue is that,
Your Honor,
nobody's called these.
Well, we got to do one at a time. So I think your point you're about to make was more to the merits. So I don't see that as germane, but Mr. Reyes, I think I take your point. Who? Right.
Add to what Mr. Beal said, we prepared a PowerPoint presentation and we are already connected to the Zoom meeting. When I was reading through your email this morning, I figured that there might need to be some sort of redundancy available, so we have the ability to share that electronically on the Zoom platform. So Mr. Reyes is everything in real time as it's being placed into that.
All right. So understand the positions and arguments of both. I think that we can see how this goes. If there's something that is presented or comes up in a way that Mr. Reyes, you can articulate specifically is impeding you, then we can deal with that. But at this point, I think that the reality is it was noticed today. I don't see, based on these pleadings, what's going to be so material that, we're going to need someone in person for this. And I think there are ways around it that we can work through. So it's noted for the record, but I'll deny the motion right now. But if sometime in the middle of the hearing you need to renew that for some particularized reason, feel free to raise it. As a matter of, again, housekeeping to move on and narrow the issues of what we need to address today. Again, I've reviewed the pleadings. We're here on the second motion for the contempt, the supplemental, and now this third motion filed last month. And I've reviewed also defendants' responses to those, as well as the motion to strike the supplemental. And specifically when it comes to the supplemental, looking at the statute cited, I don't see and the law doesn't seem to indicate that a contempt motion is considered a pleading. And so I don't think that has any merit. And so I'll deny that motion. And anything raised in the supplemental brief would also be relevant and for today's hearing. And with that, I also don't really think there's a need for kind of an opening. I think I'm very familiar with the parties' positions. It's going to come down to a question of the circumstances, the intent. If there's any additional evidence we need to consider, I'd say let's get into the evidence. So with that, unless Mr. Reyes, there's anything else you want to address on the front end, I'd ask Mr. Beal to call your first witness or introduce your first exhibit.
well, Your Honor, nothing from me. Thank you.
Your Honor, I was going to do an opening, but it sounds like you're ready to go.
I don't think we need it. I mean, I think I know what's in the pleadings.
All right, then I'm going to turn it over to Ms. Brown, who
Mr. Exum?
put all the evidence in.
Yes, sir.
Real quick, sir, you said you reviewed our responses. Does that include the reply to the motion?
The one Friday? Or, yeah.
We submitted a reply to the motion to strike in early December.
I'll make sure I don't know if I have that one printed in front of me. When it comes in, I read it. I'll take another look at it to make sure, and we can revisit that. All right.
Okay,
What else?
that explained the,
All right.
Which account are you sharing your screen from?
Michael Blossom.
Okay.
Your Honor, do you want us to put all the defamatory posts into evidence, or are you just going to take judicial notice of them? How do you?
Well, I guess you can tell me if you've got them all compiled as a exhibit or how you do it, and we'll see if they're objected to, and we'll make a record as we need to.
Have you got them all on the thing?
They're all gonna. So I don't know what they're. She's got all these kind of PowerPoint. They're from brief.
Yeah, but the brief is incomplete about some of them.
The only thing I want to try and avoid this time around, we can learn from experience, is I don't need to have them introduced one by one and then read to me, right? So if you've got some kind of a comprehensive exhibit that you want to introduce, and then Mr. Exum or Mr. Reyes, if you want to supplement it in some way, then you're certainly welcome to. But I think the piecemeal one by one isn't the best use of all our time.
All right, thank you. That's good advice, because we were headed down that road. We can have somebody authenticate them, Your Honor, I think.
Well, that's up to the defendants if if there needs to be authenticated, if there's an objection to their admission.
Well, I mean, you represent to me that they're from
They are.
the Telegram channel
Yes.
and that they are complete,
Yes.
then they are what they are.
Okay, just for the record purpose, I don't know if you heard that, but the parties are going to be stipulating as to the authenticity of the Telegram posts that are being displayed in this PowerPoint. And to the extent that there are any questions, we can handle that. But we represent that these Telegram posts were captured at or around the time that they were made by Defendant Wood. They are complete in their entirety. I will note for the record, there is one post that has a redacted screen box over a picture of a minor child for obvious purposes.
And so are we going to mark maybe a copy of this PowerPoint as plaintiff's one?
Yes, Your Honor. I think that's a lovely way to handle this.
Okay, and then you can provide me a copy digitally, inclusion of the hearing, and one for our court reporter as well.
Yes, Your Honor, we can definitely do that.
Okay, Mr. Reyes, any objection to admission of plaintiff's exhibit 1?
I have not seen the exhibit, Your Honor. I only see the cover.
All right. Can we provide a copy to Mr. Reyes and Mr. Exum, Mr. Wood, and perhaps they can confer as to whether there's an objection and the grounds for the objection?
Yes, Your Honor. We'll have Mr. Glossop send that to them right now and stop the screen share. And so then they can have a moment to look at it then.
I mean, I don't know if you have to stop the screen share. We just need to get Mr. Reyes to get on board, or I don't know if his client needs to be in touch with him to let him know his position on it.
Okay, Your Honor, it's been emailed to Mr. Reyes, Mr. Exum, and to the court as a courtesy copy. And we'll just go ahead and start flipping through these.
Well, I think we want to wait until we get Mr. Reyes' as formal position on their admission before we move forward. Mr. Wood, have you been able to be in touch with Mr. Reyes during this process?
No, I got a copy of when John asked him about the second link. He didn't know, he didn't have it. But if I can have the time, I'll speak with him by phone in private, if that's okay.
Whatever you prefer, you can use our jury room if you'd like. Then are there any other exhibits the plaintiff plans to introduce other than this omnibus exhibit 1?
No, Your Honor. And all of the Telegram posts, except for the post that Mr. Wood posted over the weekend, are included in the pleadings. This most recent round of disparaging remarks is really just to show the court
There's something in
intent.
addition to what was in the motions?
Yes,
that
Your
just
Honor.
happened?
Over the weekend from the 2nd all the way through today. And those are just included as further evidence of intent of willful violation. But other than that, every single one of the screen captures appear in one of the pleadings.
All right. Then why don't we hold in place? We'll allow Mr. Wood to step out and talk with Mr. Reyes as to.
They have these new posts.
It sounds like they're all contained within this one plaintiff's exhibit 1.
Can you send it to John Exum too? Can you send it to John?
Did you send it to me, Michael? I don't have it yet.
I don't have it yet either.
Do you have it, Ibrahim?
Not yet.
I just got it.
Okay, so we're going to go off the record in just a moment, and I'll come back either at the direction of the parties or check in about 20 minutes. And again, Mr. Wood, you can step out if you need to make that phone call, and we can then move forward from there. Mr. Beal.
If you want, Your Honor, we can do the second motion. Right now, all of that is already in evidence by 2 different affidavits. So we are here today on the third motion, but everything to do with the second motion is teed up and ready.
The second in the supplemental
Yes, Your Honor.
by way of affidavit?
Yes.
Could I really be considering that by way of affidavit? This isn't like a motion for summary judgment, right? Don't I have to hear live testimony at evidentiary hearing?
Well, Your Honor, the affidavits will bring them all into evidence. And we can certainly,
It wouldn't an affidavit though if it's, I don't know. I mean, I can't substitute that for in a live evidentiary hearing, can I?
well, we're prepared to do that
Yeah.
also, Your Honor.
So, I mean, correct me if I'm wrong. Otherwise, I would think that needs to be either addressed through stipulation or.
They're in there also.
Okay, so apparently these are all in the omnibus exhibit 1. And then I guess the other follow-up question I'd come back with is, I know this PowerPoint is beautiful and you can't wait to show it to me. I'm wondering, other than plaintiff's exhibit 1, is there any other evidence you plan to introduce? Okay, so what I would say is rather than walk through the PowerPoint, we reserve that for more of a closing argument because that's where your arguments are. I want to see what evidence I'm supposed to consider first, and then I would turn it over to Mr. Wood to see if he has any evidence to present. All right, we're off the record.
In the building, then you have the seventh one upstairs. You gotta walk that, the elevators, I think the first floor, elevator, the first floor, the cafeteria is closer, on the first floor to the elevators versus the 7th. Yeah, that's good.
At the end of it.
Yeah, it's water, the water fountain right there. You know?
It's number 2.
You looking? That's it. Ibrahim. And
Yes.
Yep.
Abraham, are you done? Are you guys good?
Yeah, I'm done.
Okay, can we get the judge back?
When Mr. Wood and Mr. Exum are there, sure.
Jump.
Mr. Reyes, now that,
We're not on the record right now, and unless you're just doing some housekeeping, just FYI.
I was
Do we want to
just
go back on the
gonna ask
record? Okay.
his position, because I think he said he was ready.
Okay. Well, then we just need to get his client back. All right. Here we go. All right, let's go back on the record. We have all the parties have rejoined us, and I believe Mr. Reyes may have had some time to confer with Mr. Wood in private and review the omnibus plaintiff's exhibit 1. Mr. Reyes, do you have a position as to the admissibility of plaintiff's exhibit 1?
Yes, sir, and thank you for the opportunity and the time. We do have to object to these exhibits for the reason that this is a motion on PowerPoint. These are not exhibits. If the judge notices every exhibit has argument next to it, this is just a motion on PowerPoint, not exhibits. That's one. Secondly, the newest posts that they wish to introduce, we have no notice of that. We had no idea that that would be part of today's process. They didn't file any brief motion pleading on that. So yeah, we do object to these, to what is being represented as exhibits, that they're not exhibits. They carry a lot of arguments.
All right. So I have not seen plaintiff's exhibit 1, so I take it that there's exhibits and then there's maybe other slides with talking points and that sort of thing. So, all right, Mr. Beal, any response?
Your Honor, it'll only take us a minute to go through and we can authenticate each one that way. We believe that all of the exhibits that are contained in the second motion should be authenticated. They are true and accurate copies. And we can simply, they are authenticated by affidavit and we will put them all into evidence live through Ms. Wade. And it's not going to take long, I promise. And that way you don't have to hear us on closing.
That's fine. All right. Well, then if there's not any stipulation or agreement from the parties as to what comes in, then we have to do it the other way. So you may call your first witness.
Plaintiffs call Nicole Wade to the stand.
You swear right that the testimony should be in accordance. Help you. Please make the spell your first and last name for the court.
Nicole, Nicole, Wade, Wade.
And Your Honor, since Mr. Reyes is remote, it just, since we're getting these for authentication purposes, I'm going to have Mr. Glossop screen share these. I only have one copy for the witness to look at. I apologize. May I approach witness?
If it's your witness, feel free to approach all you want.
Ms. Wade, I'm handing you what is labeled and titled as plaintiff's second motion for contempt and brief in support of. Will you take a moment and look at the contents of that pleading and your affidavit attached, which is Exhibit C to that motion? Ms.
Okay, yes, I've looked at it.
Okay, and we'll give Mr. Glossop 1 second to get that on the Zoom screen share. Okay, what's being displayed on the Zoom link, Mr. Reyes, is just a copy of plaintiff's second motion for contempt and brief support thereof, which I've already handed a copy to Ms. Wade to look at. Ms. Wade, speaking solely to the Telegram posts that are capture and appear in this second motion and in your affidavit, are you familiar with those Telegram posts?
I am.
And did you capture those Telegram posts at or around the time that they were posted?
I did.
And what Telegram channel did you take those captures from?
From Linwood Speaks Truth.
And is that the main Telegram channel that that defendant Wood utilizes on Telegram?
Yes, and let me just correct that. Some of them are from Linwood Speaks Truth, and some of them are from his second channel, Reply to Linwood. But both of them are channels on Telegram on which Mr. Wood makes these posts.
Okay. Thank you, Ms. Wade. Your Honor, at this time, we'd like to publish this pleading and its affidavit as Plaintiff's Exhibit 1 for the purpose of introducing into evidence the Telegram posts that are captured and appear in the motion in Ms. Wade's affidavit.
Okay, so plaintiff's exhibit 1 would just be the July 5th, 23 second motion for contempt. And so that's being tendered for admission. So I'm going to you or Mr. Reyes?
Well, I'm gonna need to talk to Mr. Reyes because they're tendering as an exhibit their legal brief. Same problem they had with.
I mean, that seems odd to me. I can't say I've seen that before.
Well, then we can place into evidence just Ms. Wade's affidavit in support thereof.
Brief can't be part of evidence.
And there's someone's unmuted. We just need to do that to get rid of the echo. Okay, what was that, Ms. Brown?
I said we can submit Ms. Wade's affidavit in support thereof only then as plaintiff's exhibit 1.
Okay, so plaintiff's exhibit 1 being the affidavit and
Which is the affidavit to the second contempt motion. It's attached as exhibit C to the,
all right, does that also contain these specific posts?
yes, Your Honor.
Okay, all right, so remarked or re-identified plaintiff's exhibit 1 being the affidavit of Ms. Wade. Objection to plaintiff's exhibit 1.
We don't have the affidavit.
It's exhibit C to the
Send us.
2023.
Okay, will you give us a minute? Thank you.
Now, Linda, do you have, we could look at one, wait a minute.
It's on screen. I'll scroll through it, and if you need me to slow down, just say.
This is going to be page 175 of the initial July 5th, 2023 motion. And it contains some exhibits in there as well. Or some screenshots, rather. Notarized statement of Ms. Wade. All right, objection to what's been now marked and identified as plaintiff's exhibit 1.
I hadn't had a chance to see it,
Well, it's part of the record. It's been there for a while.
but I don't know. I wasn't prepared to deal with it. I need to talk to Mr. Reyes, but this has the same problem, is that it contains statements by Ms. Wade, and it's not just identifying or authenticating the actual post. Now, they've had plenty of time to get the post separated from their arguments and their argumentative affidavits and present them in evidence in an orderly fashion. The way they're doing it now is wrong, and we have no choice but to object to it.
Yeah, Your
All
Honor.
right, well, Ms. Brown, why is this not all these other statements in here? I wouldn't, to his point, would that be, essentially, it's an out-of-court affidavit that seems to be hearsay in its basic definition.
I can have Ms. Wade walk through this. Your Honor, at the last contempt hearing, we submitted the telegram statements in this exact fashion and in a PowerPoint presentation.
I agree, there was no objection back then, as I recall, so.
And if we need to, I'm happy to walk the court and Mr. Wood through every single one of these posts.
Well, how about this? If you were to provide instead as Plaintiff's Exhibit 1, redact everything on this affidavit except for the screenshots and the date and time that Ms. Wade testified that she captured them, would you be able to do that?
Yes, Your Honor.
Okay, so if there was a redacted version submitted and tendered as Exhibit 1, would there be an objection to that? Mr. Reyes?
Do we have? Because, at the previous hearing, Your Honor, we were shown exhibits, and the exhibits were posts. They did not contain the mental impressions of the plaintiffs. They did not contain.
I understand that. We've moved beyond that, Mr. Reyes. We're saying we're going to redact and black out everything other than the posts themselves and the date and time.
Before we go through them?
Have the right to see it, the redacted affidavit.
I agree with that. And so reserving any objections you would have to the final copy of that, if it before us as these affidavit is redacted, would you have any other objections?
If it only contained the posts that are gonna be deemed exhibits, no problem.
Yeah.
All right. So reserving your ability to object to specific aspects or posts if for whatever reason you think that they were not contained within that affidavit or improperly redacted, I'll say it's conditionally admitted.
Thank you.
As plaintiff's exhibit 1.
And when can we get the redacted?
Well, we'll see what we can accomplish today and go from there.
Thank you, Your Honor. Ms. Wade, I'm gonna hand you another affidavit that was submitted in November of 2015.
Okay.
And Abraham, we will do the same thing with this affidavit, where we redact everything but the post. All right, Ms. Wade, have you had an opportunity to look at your affidavit from November of 2023 that I handed you?
Yes, I have.
Okay, I'm gonna walk you through some of these posts. In paragraph 3, can you explain?
Excuse me, Your Honor. I'd like to void dire the witness on her qualifications to authenticate these posts.
All right. Well, when she tenders an exhibit, that would be, I think, the appropriate time to make that objection. Ms. Brown.
Ms. Wade, the Telegram post screenshotted in paragraph 3 here, did you take the captures of these Telegram posts that are depicted here?
Yes, I did.
Okay, and were those screen captures of these Telegram posts made at or around the time that they were made?
Yes, they were.
A true and accurate reflections of Telegram posts that Mr. Wood posted at these links that are contained here in paragraph 3?
Yes.
And if somebody had any sort of questions as to the authenticity of these posts, could they just click on these links and it would take them directly to Mr. Wood's Telegram posts and these exact posts that he made at that time?
Yes, all of these posts, you can click on them and it gives you the option to copy the link. And so that's what you see at the end of paragraph 3 on page 2. Those links, yes, those are the links that are just, you click on copy the link to this post and that's what you get.
Okay.
And so they were done on both channels, Linwood Speaks Truth and Reply to Linwood.
Okay, and those are 2 separate Telegram channels that Mr. Wood posts on?
Correct. The Linwood Speaks Truth channel does not permit replies, and the Reply to Linwood channel does permit replies.
Thank you. The Telegram post in paragraph 4 of this affidavit, is this Telegram post a true and accurate screen capture of?
You already asked her about collectively throughout the entire affidavit, right?
I have not, Your Honor, for this affidavit. If you would prefer,
Why don't we try
Mr.
that?
Reyes made a comment as to authenticity, so I figured we could go ahead and get ahead of that. But if you would like me to do this as one, I'm happy to do that as well.
Give that a shot and see where it takes us.
Okay, yes, Your Honor. Ms. Wade, did you have an opportunity to look through this affidavit that I handed you that's on the screen right now in its entirety?
Yes, I did.
Speaking as to the Telegram post, the screen captures of the Telegram post depicted in this affidavit that you submitted, are all of the screen captures true and accurate reflections of Telegram posts that were posted either on Linwood Speaks Truth or Reply to Linwood?
Yes. Yes, they are.
And were they all captured by yourself?
Yes.
And were they all captured at or around the time that they were made?
Yes.
Your Honor, we will tender this as plaintiff's exhibit 2, subject to the redactions that we will be providing for the defendants. And so at this point, we would submit that this be tendered conditionally on that as plaintiff's exhibit 2.
All right, any objections to plaintiff's exhibit 2?
Same objections, Your Honor.
Same objections?
Yes, sir.
And Mr. Wood rises.
Well, for just a very brief void eye on.
Okay, so at this point, Mr. Wood, I think we would just kind of as a matter of tradition here, I don't care which one you want to do, but I think we need to choose who's going to be taking lead, right?
You took that away from me.
Well, no, not necessarily, because Mr. Reyes could voir dire this witness
I understand that.
entirely. So if you want to do it, do it. But I'm just saying, when I ask for objections, I'm going to go to you first instead of Mr. Reyes for this witness, if that's how you'd like to
Problem,
proceed.
I don't have the ability to confer with in real time about making an objection. That's what I'm being deprived of.
All right. Well, if you'd like to voir dire the witness, you can.
You go. How long have you been posting on Telegram?
I have, it's difficult to answer that. I have made only a few posts ever on Telegram.
Well, what is the name that you're on Telegram under to be able to get into my channel?
To make these screenshots, I have an account called Miss Thing.
Miss what?
Thing.
And how long have you had the account Miss Thing?
I don't remember when I set that up.
Well, if you had it the entire time you were taking these posts down, you said you took them down almost contemporaneously with when they were made.
At or closely thereafter.
Do you post on Telegram under the Miss Thing name?
I've never posted under that name, no.
And you still have that name?
I do.
Do you remember when you were examined back at an earlier hearing, you were asked, do you post on Telegram? Your answer was no.
That's correct.
And then Mr. Reyes said, have you ever posted on Telegram under the name Jellybug? And then you changed your testimony and said it's an N, there's an N at the beginning of it, but yes, I have posted. You didn't mention Miss Thing.
Objection, Your Honor.
Did you?
Well, hold up. Okay, now what's your grounds for your objection?
Relevance as to laying the foundational requirements as to this witness authenticating these telegrams, screen captures that we're submitting into evidence.
All right. Overruled, Mr. Wood. You can keep laying your foundation if you think that.
Well, I think I've laid it. She comes in and wants to authenticate from Telegram. She's not told the truth at a prior hearing about who she is on Telegram. I don't know if she's the one that pulled these down or not. I think it's a serious question. When a witness says they don't post on Telegram and then they turn around and admit they lied, and they do, but they don't mention the account, Ms. Thing, I think it raises some question about the credibility of her testimony that she's the one that authenticated these.
All right. Was there anything else you wanted to? Okay, I see you sitting down.
Your Honor, I'm sorry. May I answer the question? There was a question and you overruled the objection.
If I overruled the objection, he's still out there and he's still asking it? I suppose she can answer, but that's up to a witness, not to me.
I don't know what question she's referring to.
You asked me about the question that you had asked me. Actually, it was you, not Mr. Reyes, at the previous hearing. And the answer is that I did not have that account then, and I did not lie when I gave that answer. You asked me if I post on Telegram. I don't have a channel or channels like you do, so I don't do that. I had made a couple of comments So when you ask me, do I post on Telegram? I think about what you do, and I do not do that. I had a handful of posts.
All right, I think,
the-
Mr. Wood, you stand by your previous argument?
Well, just with what she's just said, I'd like to finish up real quick.
I think you can take that up on cross. To your point, the sole question here is admission of Plaintiff's Exhibit 2. And you've ordered it based on whether she has the, the qualifications and the foundation to admit it. I think you've raised points that you can argue for credibility. I think it goes to its weight. I don't think it goes to its admissibility.
Okay.
So as it goes to Plaintiff's Exhibit 2, do you have an objection?
We have the same objections
Yeah.
that we had
All right.
to. Yeah.
And so I'll conditionally admit Plaintiff's Exhibit 2 along the same lines as Plaintiff's Exhibit 1, which is after we see this redacted version, you can renew your objections and I'll make a final determination at that point. All right.
A moment to go back and speak with my counsel by phone,
Regarding
the issues that we're talking about right now.
the issues of this credibility impeachment matter,
Right. I
let's do that at the conclusion of her direct and then before you start your
Well,
cross.
but it also goes to the question of what you raised about who's going to do the objecting.
Well, at this point, I'll allow you both to do it.
Okay?
Ms. Brown.
Thank you, Your Honor. Ms. Wade, I'm now showing you plaintiff's emergency motion for contempt and brief support thereof, which was filed on July 19th, 2024. I'm going to ask you a couple of questions about some of the posts in here. Actually, Your Honor, I apologize. I'm going to. Do that from here. Ms. Wade, the Telegram post screen capture that I am circling with my cursor. Do you see where I'm pointing you to?
I do.
Is this a true and accurate reflection of a July 16th, 2024 Telegram post that Mr. Wood made on his Linwood Speaks Truth channel?
Yes, there's part of it redacted, but other than that, yes.
Other than the one, thank you for clarifying, other than this one blacked out box, this is a true and accurate post. And did you take a screen capture of this post at or around, or at, excuse me, whenever you first saw the post, around the time that you first reviewed this?
Yes, it was the day after they were posted, I believe.
Okay. And on this second one, on the right-hand side of the screen that I'm circling again with my cursor, is this first top one a true and accurate reflection, putting the highlighting aside, of a Telegram post that Mr. Wood posted on July 16th, 2024?
Without the highlighting, yes, it is. It's actually two, it's actually one, and you can see a portion of another post, but yes, they were right after the other.
And the second portion of that post that you mentioned, it appears to be a post of a picture. Is that accurate?
Correct.
And can you just describe to the court what type of picture Mr. Wood posted in the second Telegram post?
It's a photograph of Jonathan Grunberg's daughter when she's at bath time.
Thank you. And did you capture, and for the purposes of this hearing, obviously, we're not going to put on the screen a minor child, but did you take a capture of that Telegram post at or around the time that you first reviewed it?
I did.
And is this the bottom of the screen, the picture that Mr. Wood posted that we were just speaking about?
Yes, it is.
And this middle post right here that I'm putting my cursor around, it was posted at 9:58 p.m. Is this a true and accurate screen capture of Mr. Wood's Telegram post that evening?
Without the highlighting, it is, yes.
Thank you for that clarification. And did you record this screen capture at around the time that you first reviewed it?
Again, it was the day after it was posted, yes.
And I'll direct your attention to the long post that is on the right-hand side of the screen that I'm circling again with my cursor. This one was posted at 10:15 p.m. I'll ask you the same series of questions. Except for the highlighting portion, is this a true and accurate screen capture of the Telegram post Mr. Wood posted on July 16th at 10:15 p.m.?
Yes, without the highlighting, yes.
And did you take a capture of this Telegram post at around the time that you first viewed it?
Again, it was the following day, yes.
Same questions for the two posts here, except for putting the highlights aside. Are both of these true and accurate screen captures of Telegram posts that Mr. Wood posted at 10:38 p.m. and 10:42 respectively to his Telegram channel?
Yes, absent the highlights, they are screenshots that I took the following day from his Telegram channel.
Thank you. And in this one, we have 3 separate Telegram screen captures. I'll ask you the same questions for these. Are these true and accurate screen captures of 3 separate Telegram posts that Mr. Wood posted respectively at 12:17 a.m. on July 17th, 12:18 a.m., and then 12:35 a.m.?
Yes, those are screenshots that I took, I guess it would be later that day, from posts made on Mr. Wood's Telegram channel.
And then these same questions for these 2 posts, which were posted July 7th. The one on the left hand was posted July 17th at 10:01 p.m. Is that a true and accurate screen capture of that Telegram post Mr. Wood posted to Telegram?
Yes, I took that screenshot. This one again would have been the next day, and absent the highlighting, it is a correct copy of what was posted on his Mr. Wood's Telegram page.
And on the post, the following post at 1:25 a.m., which would have been on July 18th, is that a true and accurate screen capture of that Telegram post that Mr. Wood posted?
Yes, absent the highlighting, again, that is a correct copy of a screenshot that I took. That one, again, would have been later that day since it was posted at 1:25 a.m. from Mr. Wood's Telegram channel.
Okay, and now what's on the screen are various, well, actually, can you describe for the court what what we're seeing here from Telegram?
Yes, these are screenshots of responses or comments that people who follow Mr. Wood posted on his Reply to Lynn Wood channel in response to the photographs that he had posted of Jonathan's children. We talked about the one, but there were 2 other photographs as well that he posted of Jonathan's children. And these are comments that people made in response to those posts.
And did you capture all of these comments or replies, if you will, from Mr. Wood's followers?
No, some of them.
Are all of these responses, comments, if you will, available on Mr. Wood's Reply channel for anyone to view?
Yes.
And to your knowledge, are these true and accurate depictions of those responses, except for the highlighting emphasis added?
Aside from the highlighting, again, yes.
Same questions for these comments. Are these the same types of responses or replies to Mr. Wood's Reply channel that his followers posted?
Yes, again, without the highlightings. And these, yes, they are, yes.
And to your knowledge, to your knowledge, are these true and accurate screen captures of all of these responses?
Some of them, yes.
Are you aware of any that are not accurate depictions?
Oh, no, I just meant I didn't screenshot every single reply or comment. These are some of the comments. Sorry.
Thank you for clarifying. But the ones that are depicted here, they're true and accurate to the best of your knowledge?
Yes.
You didn't manipulate these in any way, putting aside the highlighting emphasis that has been added?
Aside from the highlighting, that's correct. And I didn't do that.
Same questions for these. Are these the more types of comments that appear on Mr. Wood's reply channel from his followers?
Yes.
And to your knowledge, are these true and accurate depictions of these responses that are on the screen for you?
Yes.
Putting aside the highlighting emphasis, did you manipulate these screen captures in any way?
No.
The post that is on the left-hand side of the screen that I'm circling right here, can you explain to the court what this screen capture is?
Yes, that's a reply on his reply to Linwood channel. Deborah Warren is someone who was replying and saying, not a good look for Wade Grunberg and Wilson. I'm assuming it's the same Jay Grunberg. Am I right? And then there are a couple of comments, and then you can see where Lynn posted and responded to her and said, yes, Lynn.
Your Honor, I object to these replies. These people, that's not what I'm saying. These people say things. This is not about what third parties say.
Give me a rule of evidence, Mr. Wood.
Well, I'm being accused of disparaging them, and they're hearsay, number
All right.
one.
Hearsay. All right.
Hearsay, and they're not relevant because they're not anything I said. In fact, most of the pictures they've got here today, I didn't say a word.
Understood.
And they were posted by
All right, Ms.
Mr.
Brown,
Grunberg.
objection is to hearsay and irrelevance.
Your Honor,
Response.
it goes to Mr. Wood's intent and his willful violation of this court's contempt order. And as you see here on the left-hand side, Mr. Wood, in fact, does respond to some of these followers. And it's to show it's not being submitted for the truth of the matter asserted in terms of that this in and of itself is these comments, replies, if you will, from these followers are disparaging in and of itself. It's to go to the heart of proving that these posts were made with malice and willful disregard of this court's order, because Mr. Wood knows the impact of his statements, and it shows that his followers understand exactly who he's talking about in these posts. As you can see here, it says
You don't need to
Deborah.
repeat them to me. All right, Mr. Wood, any response to that?
I mean, it's just pure speculation that these people that are commenting know exactly what I'm doing. I don't go through all the reply channel. There's admins that monitor
Well,
it.
now I think
I
you'd be
will-
getting into
Well,
testifying and personal
well, I
assurances.
don't
but
mean
on
to
the
do
grounds
that.
of your objection on relevance and hearsay, I think that,
they're not relevant. They don't prove my intent.
well, there can be an argument that they do, and they at least can make that argument. So I
What
think on the
my
initial
intent-
grounds of admissibility,
My intent in saying,
which you can argue based either on its face or if you want to testify yourself, just on grounds of
Well, I am gonna have
admissibility,
to
I think it's
testify,
admissible.
but
And we'll get there.
but
We'll get there.
this is objectionable.
All right. Well, I overrule the
They can't
objection.
accuse me of disparagement based on what somebody else said
Mr. Wood,
and what Mr. Grunberg himself
I'll
posted.
tell you one more time. I've made the ruling. We've got to move on. So I understand your objection. I've overruled it,
Thank you.
and it's come in, and you'll have every opportunity to testify or argue on it. So
Thank you, Your Honor.
what's next?
Thank you, Ms. Wade. So on the right-hand side of the screen, can you explain to the court what this Telegram screen capture that we're looking at here?
Yes, this is actually a different channel, the Breb Room. One of the, I'm not sure it was this one, but one of the admins that Mr. Wood was talking about, T. Fletcher, posts stuff on this Breb Room as well. And he reposted some of the pictures of Jonathan's children. And then these are comments from people on that channel to this post that was reposted from Lynn's channel.
Okay, and so I
Objection,
want to
Your Honor.
direct your attention.
Hold up, Ms. Brown.
Now, if I'm following it, they're putting into evidence information posted by a separate Telegram channel. And they're trying to connect me to it because they say that T. Fletcher is an admin on my account and also on this account, Brebroom. How can that be relevant to my intent? I can't control what whoever Brebroom is. I think I met him one time years ago.
All right, so Ms.
So-
Brown,
so
do you
it-
have any additional evidence you plan to show connecting Mr. Wood affirmed it or verified it or personally saw it or signed off on it in some way?
Your Honor, I was getting to that, but in terms of directly responding to your question, again, this is not being offered for the truth of the matter asserted to say that this in and of itself is a disparaging post in violation of Your Honor's contempt order. This is being submitted to show that these individuals who are commenting understand exactly who Mr. Wood is speaking about, and that this is getting out, a picture on the right-hand side, which is redacted, is a picture of a minor child that is the child of one of my clients. And these individuals are also the individuals who are posting these comments. So again, it's just going to show
Understand, Ms. Brown.
intent.
Well, to that end, though, I understand your concern and why, you've collected these and highlight them. But for the finding I'm supposed to be examining today, I don't see how that would pass the bar of relevance. And so I think I would sustain the objection. My job today is to determine that Mr. Wood intentionally violated the order. And to that end, unless he's adopted or affirmed him in some way, like you showed at the first one, I don't think we need to explore every single response anyone's ever made to one of his posts.
Yes, Your Honor. Just for completion purposes, Ms. Wade, this reposting here that has the black redacted square over the picture, where is this original post? Where does this original post come from?
Objection, Your Honor.
Yeah, again, because other people reposted something he did, I just don't see how that's relevant to the finding today.
Your Honor, I think that the witness is going to be able to answer where this post came from because the answer is depicted in the screen capture
No,
itself.
I know, assuming it came from Mr. Wood's channel.
Yes, Your Honor.
Just because other people took it and ran with it, how does that help me make a finding today?
Understood. Ms. Wade, for the posts that are contained here, one just summary question, are these true and accurate screen captures except for the highlighting emphasis that has been added?
Yes.
And apologies, and the redacted box over on the right-hand side?
Yes.
Ms. Wade, I'm showing you now some additional Telegram posts from Mr. Wood. Are these true and accurate depictions of posts from August 1st of 2024?
Objection. This goes along with what Mr. Reyes mentioned. They've not put these into any pleading. This is the first time we've heard of them today. And that's unfair and it's not reasonable. They got to tell us what they're accusing us of and give us an opportunity reasonably to be able to respond to it. So these posts of August 1, they're objectionable and should not be considered.
So I agree with you, Mr. Wood, to the extent that you can't be considered to be in contempt for these.
Correct.
Because you haven't gotten notice. But I think that would still be relevant as to show your intent on the prior postings, potentially.
And that is exactly.
Ms. Brown, let me follow up with him.
I don't see anything, Your Honor.
I haven't even
That-
looked at them yet. I don't know.
Well, take a look at this one. I'm busy this week preparing for the upcoming Freemason tribunals in Atlanta. I'm not studying the law or the pleadings which have been filed for me or against me. I'm not preparing for legal battles.
So I can
I'm
read it.
preparing for spiritual battles.
I've read to the end here, and so
Yeah,
what
it has
what's
nothing-
your argument?
It has nothing to do with me.
It's irrelevant.
What I published, they claimed that was in violation of the court's order.
Okay. All right. I think that's going to go to its weight on its admissibility. And so I'll overrule the objection. Ms. Brown, you can continue. And if you think somehow that shows his intent from the ones we've noticed him about, then you can make that argument at the appropriate time.
Thank you, Your Honor. And to confirm, I'm assuming you mean by closing at the appropriate time? Yes.
When it's the argument phase.
Strong. Ms. Wade, are these true and accurate screen captures except for the highlighting emphasis from Mr. Wood's Telegram channel?
Yes, they are.
Same question here as to this Telegram capture that is before you. Is it a true and accurate screen capture except for the highlighting emphasis from a post from August 1st of 2024?
Yes, it is.
And here are two additional Telegram posts. Are these true and accurate reflections of Telegram posts Mr. Wood posted on August 2nd of this year?
Yes, they are.
Here are some additional ones from August 2nd of 2024. Are these, there are two side-by-side Telegram posts. Are these screen captures, except for the highlighting emphasis, true and accurate depictions of Telegram posts Mr. Wood posted this weekend?
Yes, they are.
Am I right, Judge, that we're looking at these because they claim it shows my intent?
I suppose so. That's the only way they'd be admissible. And you may disagree completely, and then we'll go from
All you got
there.
to do is read English and you'll know that I'm talking about the Holy Spirit and Jesus Christ.
Sounds like a wonderful argument when we encapsulate.
It is a wonderful argument.
Yeah. So,
When
but
the,
for
when
now,
the, when the
we're
final
just talking
judgment is
about
made, I won't have to
admissibility.
argue it.
All right. So, to the extent that was an objection, I think we've already addressed it.
Thank you, Your Honor. Ms. Wade, same question as to these two Telegram posts from August 2nd of 2024. Are these true and accurate reflections of Mr. Wood's posts from that evening, putting aside the emphasis added from the highlighting?
Yes, they are.
And Your Honor, we will provide these at the same time without the screen, without the highlighting emphasis for Your Honor and for Mr. Reyes to consider. Those posts will be what we will submit as Plaintiff's Exhibit 3.
Just to be clear, you're saying everything that you showed as part of this PowerPoint, you're now intending to pull out of the PowerPoint and compile that as Exhibit 3 with redactions?
Yes, Your Honor.
All right. Noting the other objections already raised by Mr. Wood and Mr. Reyes, are there any additional objections to the admissibility of Exhibit 3?
No, Judge, subject to the previous objections.
All right. Mr. Wood, anything you want to supplement that with?
Yeah, no, sir.
So it'll be conditionally admitted. Again, that's once the other parties actually had a chance to look at these and confirm before it's made part of the record.
Thank you, Your Honor. And that's all the evidence we're going to submit unless Mr. Wood has questions.
I do.
All right. Do you need a break, Mr. Wood?
If I might take a few minutes.
Okay, just a few minutes and we'll just
I've got-
hold in place. Yes, sir.
I've been fighting a gastrointestinal problem for over a year and a half, so.
You need more than just a few minutes?
No, I don't think so, but
Okay.
I'm really more interested in speaking with Mr. Reyes.
All right.
But I would appreciate it if counsel would put back up the exhibits that she just questioned Ms. Wade on.
And let me just, unless you need to make a run for it, I want to start off this with the cross. What I see as relevant lines of inquiry is not, hey, don't you agree with me that this post really means this, or what I really meant was this. I don't really need her opinion of what these posts said because I can just read them. What's that?
I don't intend to ask
Okay.
her opinion because I don't think her opinion is any more relevant than the opinions of the people that look at them on Telegram or on Jonathan's Instagram account. The only question is, looking at the post within the four corners, did I disparage them in violation of the court's order?
Okay. And again, I'm willing to let you explore that a little bit, but I still think ultimately that's something that would speak on its face and that you can argue in closing and then I got to make the call. I don't really see how getting into a back and forth a witness helps us at all now.
I'm not going to be that long with her.
We'll see. All right. We'll hold in place for a few minutes.
Can you put those exhibits back up there for me?
Thank you, Don.
Whichever.
I assume I can step down. for a
Sure. If you
moment.
need to, feel
Thank
free.
you.
Thank you, Your Honor.
All right. And Mr. Wood, do you still intend to ask some follow-up questions of
Yes.
Ms. Wade? All right. So whenever we can, if we can get Ms. Wade back in. And while she's coming in, I want to also add for the record that I had a chance to revisit the reply brief as requested by Mr. Exum. And I think there's some interesting points in there. I would say they're ones that certainly I would characterize them as creative in some respects, and I don't think it comes up very often. But the ultimate point, as I took away from there, is I think there was a quote that what you were essentially asking is for them to rename their supplemental brief as an amended motion, and I think there's a pretty well-worn point of black letter law that the title doesn't always control a pleading; it's the substance. So I think you could very easily interpret that as really that was the third motion for contempt, and the July one is the fourth, and the ultimate concern is due process. Did Mr. Wood get enough time to respond, and was he on notice for today's hearing? And I think those two have been satisfied.
Well, I didn't have a formal motion. I didn't have a time to respond.
But you did. You filed a response and a reply.
I had to protect myself.
So you satisfied everything you wanted to do.
I don't know. I didn't get due process. They regardless of what they named it. I'm glad Your Honor recognizes that it's not the name, it's the substance of the pleading. You could file a motion to dismiss, but the substance of the pleading could be an answer, right?
Agree.
Thank you.
And so to that end, I think that could have been taken as its own standalone motion for contempt based on new postings. And ultimately what we're getting at again is the chance to respond and notice. And I think you got both of those. So okay, I'll just add that point. All right. Did we get Ms. Wade back? Yeah, if you could come up here, ma'am, and we'll, and Mr. Wood, are you conducting this or Mr. Reyes?
I will do it. But I'll need, for Melinda to, is it Mylinda? Mylinda, I'm sorry. Put that exhibit back up you just went through with her. The ones with the pictures. Well, there was a picture. It was in that series where you were referring to Jonathan's children. There was a picture of J.D. Vance. It's that part of the PowerPoint you just examined on. That
So did you want that motion? Oh, sorry.
I proceed. Do you have you have it in front of you?
I do. Yes, I can see it on the screen.
So there's a combination under Linwood, and then there's a picture of Jonathan and his wife, right?
Yes.
Where did that picture come from?
You mean, where did you get it? I mean, this is supposed,
Where did it get published? Where did it come from? It says it on top.
your Telegram channel?
No, it came from Jonathan Grunberg's Instagram channel, didn't it?
I don't know where it came from. It says Jonathan Grunberg. I wasn't on there. I got it from your channel.
Yeah, but you see J.D. Grunberg up at the top, don't you?
I do.
And then he comments on it. And he put that on Instagram himself.
I assume that
Do you have any facts to say it's not true?
I do not. I have not seen that. I don't know. I
Did you
assume he did. I don't know.
discuss it with him?
No.
He just accused me of publishing it first when in fact it appears that Mr. Grunberg published it publicly first.
Objection, Your Honor.
I think I understand overruled. I think she can answer the question.
It appears that Jonathan posted it. Yes. And then that you took it from his social media, whichever one it is, and reposted it.
I didn't take it, but I'm happy to answer y'all's questions about that. I'm not on Instagram. So the same issue, and again, to be clear, what I did post, the pictures together, I did not say one word about those posts, did I?
Objection, Your Honor.
Based on, well, I think he's asking for objectively her state her opinion about what's on the post and what's not. And I told you, Mr. Wood, I'm trying to avoid us having to do that. If you think there's something else that was posted that was part of it that maybe I should be considering.
What I know, and I can testify and will testify, that I didn't say a word, but they're accusing me of disparaging them in violation intentionally of the court's order. Can't disparage somebody if you don't mention their name. And I didn't say one word about this. I just put the picture up. Let me go to the next one. So the bottom part of the picture on the left. Do you know the picture of Jonathan's child, or both children? Do you know where they were originally published to the public?
I do not.
Do you know they were originally published to the public on his Instagram channel?
I understand that he posted them somewhere on social media. I'm not sure where.
Publicly.
I can't tell the difference between the Instagram or the Facebook. Or I don't know, but
I'm not on Facebook either. I don't know if he is. But you are aware that he admitted in his pleading that when I posted them, republished them, that he immediately went to his Instagram channel and made it private.
I don't know if he did that or not.
So you haven't discussed with him whether he published those pictures publicly first.
It's my understanding that you got them from his social media. That's my understanding.
And your understanding is wrong. I didn't get them. Somebody else got them and sent them
But
to
don't you think this would be something better for your testimony, Mr. Wood?
Yes, Your Honor.
All right.
All I know is you posted them and they apparently came from his social media.
From
That's all I know.
Jonathan's,
Yes.
which meant he had to publish them first before me. Right?
That would follow, yes.
And I'm being accused of disparagement for publishing without comment a picture that he had earlier published himself.
I don't think they were without comment, so I don't
didn't
agree with
comment.
that.
Find a comment on there. On that. There's not a comment on there.
All right.
Have you follow my Telegram channel closely, don't you?
No,
Jonathan does, doesn't he?
I don't think so, no.
Do you see that on my Telegram channel that I frequently post pictures without any comment on a variety of issues?
You post pictures, your comments either come before or after or with another picture or that sort of thing.
Well, I'm being accused of disparaging you, and you're relying on one picture that's just two spotlights. I didn't say anything. You know that one, don't you?
I do. Yes.
Do you know how many times I post that picture and for what reasons I post it?
It appears to me that you post it when you're trying to shine the light on someone for being a purported pedophile or human trafficker or communist or Freemason.
I moved to strike that. There's no evidence of that.
Well, I'll say you just strike the whole line of testimony entirely because this isn't the right witness to get that in through. If you want to comment, she didn't say she watches your posts closely.
Well, and then she just sat there and rolled off a stream of things she claims I put the spotlight up about.
And so I agree that she's not the best one to talk about these things.
Do you know whether or not I post the spotlight periodically to reference individuals that President Trump is spotlighting?
Possibly, yes.
In the right side of this 10:15 p.m. post, do I mention your name or Jonathan's name or Taylor's name?
No, you didn't have to.
Have you followed me long enough, even if not frequently enough, to know that I advocate against pedophilia and human trafficking, especially child sex trafficking? I gave a big speech about it in Tulsa in April of 21. Have you ever seen that speech?
No, I'm aware that you say things like that.
No, I advocate. You know, I publicly advocate for honest elections.
Again, I know that you say things like that, and I know that you filed lawsuits.
I did, and they were good. Just couldn't get the court to agree with that standing. So, you know, I support President Trump.
I do.
And I love freedom. I bet you do too.
Objection, Your Honor.
I love freedom, sure.
I say I love we the people.
Mr. Wood, I don't think I want to go through the entire post. I take your point. I understand your point.
I want to make sure, Judge, because I'm being accused of intentionally violating your order. And this is free speech. And they want to come in and say, oh, he put up a picture that Jonathan had published, and somehow I'm accused of branding him a pedophile.
So, well, let me just jump in here, Mr. Wood, because if I'm pure impatient, it's not because I want to stop you from saying and arguing all these things. I want to hear your finest closing and argument and summary here. I just don't understand why we're doing this during the evidence phase of this.
She put it in there.
She put in the authenticity because you insisted they be authenticated. Their legal effect and how I should interpret them, that's what we're going to decide.
Well, it's clear that she wouldn't be someone that could speak to that, would it? Isn't it?
I think you said at the outset, and I was agreeing with you that that's a call that we're just going to have to make based on how they stand alone. If you have something outside, just
let me see what's the next slide, if you don't mind, Melinda. Do you recognize that I frequently, in fact, well, you characterize it. Do you recognize that I frequently post scriptures from the Holy Bible on Telegram?
You do, yes.
And the KJV footnote to the above scripture that I posted at 10:42, have you looked at that KJV, King James Version footnote, to see if I accurately described what reprove stands for, what it means in the Bible?
I did not, no.
You know that I don't like the devil.
So you say, yes?
You question my faith.
I don't know your faith, Lynn.
You haven't been reading my Telegram channel very well or talking to the people that do know me well. Do you know that I oppose Freemasonry?
Apparently.
That I believe it is the veil for the worship of Lucifer, the devil.
You have said that repeatedly.
Go to the next one if you would. There's a spotlight in the woodshed. I didn't say a word about it. Just posted them. Have you checked to see how many times I've posted those without making a comment?
Again, the comments come before and the comments come after. You
No.
tell your readers
In
to
the,
put the dots together, whatever it is you say.
I tell people all the time, do the research, connect the dots, and draw your own conclusions. That's called critical thinking. To avoid being brainwashed by believing what you see without verifying it yourself. What does that have to do with these pictures? I didn't say one word when I posted those pictures.
Well, because you post things before, you post things after. Just last week, you posted something that said, I love it when my followers are able to put the dots together correctly.
I do.
Which proves that you are trying to say something when you're telling them to connect the dots and put all these posts together.
That's pure speculation.
All right, so we need to get back to question and answer format here.
Yeah, but the point being, you make an assumption that when I post something, that somehow the post before or after relate to it, but you don't know that. It's just a pure assumption.
Well, for example, the one you showed before where you were talking about the King James, that referred to one before. You do that all the time. They all flow together.
I do that when I quote the Bible because I have to break out the actual scripture and then separately post the footnote in terms of what it means. Flip another one. Back. Thank you. On the right side, it says forwarded from Daryl Powell. Right?
Yes.
And he has apparently posted a profile picture that you put up about yourself, Nicole Jennings Wade, right?
Yes.
And then he makes a comment. Nicole Jennings Wade, Princess, that's the singer, I guess, logo is laced with Freemasonic satanic imagery. I didn't say anything about that, did I?
I don't know if you said that or he said that. I can't tell.
Where is my post? I forwarded his. That's his post. It's not mine.
I don't know. I can't tell who said what. I just know that you
All right, so you
posted the
can't-
whole thing.
You can't accuse me of what the substance of that post said.
Well, yeah, you posted it.
I republished it.
As you know, the tail bearer is as bad as the tail maker.
No, I know this. I know that the
All right,
law
Mr.
says that
Wood.
when you republish something without changing the content,
Let's talk about
you're
the
not
law
liable.
when we're talking about the law. Right now, we're supposed to be talking about the evidence. So I'm gonna cut this short if we
All
can't
right.
get to something on
Flip
point.
to the next page if you don't mind. Do you notice that I often dedicate songs to people?
I have seen that, yes.
Do you see where one of the complaints you said, so I will summarize the list by simply dedicating this song to the children of the devil.
Yes.
Do you know how many children of the devil there are in the world?
I know you think that it's a lot.
I know the Holy Bible says that if you do not believe in Jesus Christ as your Lord and Savior, then you are a child of the devil. And that's why we pray for the children of the devil, so that hopefully they will believe in Jesus Christ and go from being a child of the devil to being a child of God, the God of the Bible.
Objection, Your Honor. Mr. Wood is now testifying.
All right, and I think we'll get into
I may
that.
be-
BW right above it. He referenced-
I understand, Ms. Brown. I don't need to be spoon-fed. Mr. Wood,
Yes, sir.
do you think children of the devil is a good thing to say about somebody or a bad thing to say about somebody?
Well, a lot of people are thrilled to be children of the devil. They do it by choice.
Okay.
I mean, did Jesus say something bad when he called them children of the devil? You accusing me of saying something bad? Are you accusing Jesus Christ of saying it? Because he's the one that said it.
All right, well, we can flesh that out when we get to
He's flush it out by looking at the Holy Bible.
your testimony or doing the arguments. Is there anything else in this
Responding to
way
your
that you
question.
think is evidence we need to hear?
Was I right on that post about the birth dates of Jonathan and Taylor's children?
Objection, Your Honor. When it goes to a minor's birthday, we would respectfully request answer that Ms. Wade not answer that question since we're live on the YouTube. For the purposes of relevance,
All right, what's the relevance of whether the birthday is correct or not?
The post is accurate.
Okay, as to that point,
And then I ask the question. First, I say God plans everything. So when I post on Telegram often, I know that there is a reason for everything God does. I know that there is a reason for everything God allows to happen, because God is sovereign over everybody. Everybody in this room, He is sovereign. He just doesn't happenstance let things happen. There are no circumstances. So I made the point, here's the birthdays. God plans everything, and then I ask a question.
all right.
Sometimes,
Mr. Wood, I take your point.
You
Again,
understand?
and I'm telling you, I'm going to give you every opportunity to go through each of these posts if you want to, but this is the last time I can warn you. Whether Ms. Wade stays up here for you to get in this back and forth,
I was talking with you.
and we're going to have that chance. I'm just saying right now, this is the evidence portion. Can Ms. Wade step down, or do you want to have that conversation?
Go back to the one before. The one before that. And the one before that. And the one before that. I think we covered that one. Are you familiar with lawfare?
I'm familiar with you talking about lawfare,
Are you familiar with what President Trump says about lawfare?
only as you republish it.
So you don't keep up with President Trump, I guess.
Objection, Your Honor. That's-
So do you have any basis to disagree with what I described? Lawfare is the use of our legal system to attack one's political opponents. In my opinion, lawfare is an abuse of our legal system. I view lawfare as a form of spiritual warfare. Do you disagree with that?
I-
All right.
I'll put it in.
I know, but that doesn't mean this is a relevant question for this witness.
Well, she was the one that
She authenticated as opposed to yours to its legal significance. That's reserved for argument.
Go back one. And one before that. One before that. You are apparently familiar enough with my Telegram channel that you know I post sermons from the late Charles Stanley and from Pastor Ray McBerry in Griffin, Pinnacle Baptist Church. You've seen that, haven't you?
I have.
Are you familiar with Apostle Paul? I'll tie it together.
All right, better get to it.
I'm going to get to it. If you read the Bible, you know what I'm asking. I'm not saying you don't. Apostle Paul
Just ask the
used
question.
every opportunity.
Just ask the question, please.
Are you aware that Apostle Paul said that you're supposed to take every opportunity that you have to share Jesus Christ with others, to save them from spending eternity in hell? Are you familiar with that statement?
Objection, Your Honor, relevance.
Yeah, Mr. Wood, I think we got to be a little more succinct than that as to why this is, what's the question that Ms. Wade, you need in the record that no one else can answer?
Do you have any idea? You apparently keep up with my channel, reply channel. Do you have any idea how many people have thanked me because my Telegram channel has brought them to Jesus Christ and brought them closer to God? Have you kept up with that?
Objection, Your Honor, relevance.
Overruled. You can answer the question, Ms. Wade.
I see that some of those people seem to worship you, yes.
They don't worship me.
They seem to.
I think they love a fellow. Well, I'm not going to argue. And I moved to strike that they worship me. It's offensive. They follow me.
Her opinion.
They also worship the person they do worship. The King of Kings. I have nothing to put.
All right, any redirect?
Briefly, Your Honor.
Ms. Wade, when Mr. Wood was examining you, if there were questions regarding how do you, that he didn't say, he didn't mention any of you by name. Do you remember the questions he was asking you about that?
For some of these posts, yes. Some of them we are named in, but some of them, yes, he did reference that.
And so this specific thread of posts that he walked you through from July 16th this year, what about does the timing of these posts mean anything to you when you're reviewing Mr. Wood's Telegram thread?
Objection, Your Honor. That's pure speculation.
Well, I don't know what the timing is. Maybe it is relevant.
The timing that she saw it or the time that I post something?
I'll clarify.
She's going to rephrase the question.
Ms. Wade, was this first post on July 16th posted at 9:44 p.m.?
Yes, it was.
And then this next post on to the right that says right below it immediately, I know my enemies in lawfare and why they are my enemies. And it goes on. Was that posted at 9:54 p.m.?
Yes, it was.
So these messages, these Telegram posts that come back to back like this, and it continues after he posts a picture of Mr. Grunberg's child at bath time at 9:55 p.m. 3 minutes later.
Is the point of this direct just to show me the passage of time? I mean, I take judicial notice that the posts occurred and when they occurred.
Yes, Your Honor. I will move on.
All right.
As to all of the responses that we went through and saw, and the ones that you reviewed on Mr. Wood's reply channel, did you ever see any attempts by Mr. Wood to stop or correct any of the responses that called Mr. Grunberg, accused him of child sex trafficking, called him a pedophile, mentioned him or your law firm or any of your business partners by name?
No.
And we saw the post where he calls you guys the children of the devil. That's in the same
Objection, that misstates the post.
Objection, it misstates the post. Doesn't say.
Children of the devil is the exact phrase.
And I
from
define
this
children of the
telegram.
devil. It's the people that don't believe in Jesus Christ.
All right. I'll let you make that argument. And when you're summarizing. Okay.
Ms. Wade, does Mr. Wood identify you and your business partners here where he's referring to people as children of the devil?
Yes.
How does he refer to you guys as?
I'm sorry?
How are you guys referred to in this post? Can you identify that?
WGW is our law firm. It's what we're frequently referred to in the litigation.
Nothing further, Your Honor.
Do you have the slightest idea how many posts I delete on my reply channel when I have time to go in and look? Do you know whether or not I made it at least what I was able to do, where people said something about Jonathan being a pedophile or a pedo? When I was looking at the channel, I deleted them. Did you know how many I deleted?
I don't know if you deleted any. I don't know that.
You have any basis factually to dispute that as being true?
I know that all of these disparaging posts that you've made about us, they're all still available. You haven't deleted any of them. And there's still horrible things that people have posted and said about us that are still on your channel.
Well, you're blaming me for that.
I am, because as you just
Somebody
said, you
else
could
said
delete
something.
them.
That what?
I am, because as you just said, you could delete them and you don't.
I don't have 24/7 to go in. But people are entitled in this country to express their opinion. And I don't make a habit of deleting someone's opinion if it is written without profanity and it has some factual basis. If I see somebody come into my channel and accuse Taylor Wilson of being a pedophile, I would delete it immediately.
Well, Jonathan Greenberg is not a pedophile either.
I never said he was.
Mr. Wood? We're gonna
I never
stop
said
it
he
right there.
was.
Mr. Wood,
Yes, sir.
please do not interrupt me, and let's not have that happen again today. Ms. Wade, you can step down.
Thank
Thank
you.
you.
I now have a bathroom break.
All right. We'll be back in a few minutes here. Do you have any further witnesses, Mr. Beal? Ms. Brown?
No, Your Honor, no.
Okay. And Mr. Wood, you intend to take the stand when you return?
Well, don't you want to hear from me?
Don't we all? All right.
Well, I'm glad. I'll talk about Jesus if you want me to.
We'll keep it within the rules of evidence, and we'll be in recess for a few minutes.
Paul that when he preached.
Well, they weren't applicable, were they?
In fact, they're not really applicable, period.
We can explore that. All right, we'll be
They
back.
may be applicable in this world. I don't think they're applicable when you leave this world and go to the next spot. Heaven or hell.
All right, back in 5.
Hey, Lynn. Listen, something interesting. My Linda says, showing that those last exhibits, let me get to them. She says that after you posted
Oh,
photos of rooms.
there's no eating in the book.
Hold
There's no eating, no eating.
on.
No eating.
Let him know he's you, we're hearing his client conversation for that.
But you guys have, you step out in the hall. I need to. But there's no chewing gum and anything like that in the courtroom.
So you asked us to step out?
No, y'all fine. I'm just talking about the ones who want to eat something. No chewing gum in the courtroom.
So how's the traffic on sitting at 585 these days?
It's gotten.
Me, like,
Yeah, I can do it too, real well.
I bet you can do this, guy. Let's think that.
I can get it. Seven, I'm not scared.
And they want one of those parents.
That's what you said. That's why I should have better bring my jacket. That's usually with their condition.
What is in order, man? Feed it.
Put me under the gun today, Judge.
Go away.
Not letting Ibrahim be here to handle this.
I think you're doing just fine on your own.
I'm doing the best I can. Ibrahim is gonna try to conduct my direct examination.
Alternatively, if you, I mean, as I've seen it before, if you want to, you can do that, or give a, you know, a narrative account. I don't know what you prefer.
I'm trying to do it narratively. If there's a problem, then just let me know.
All right. Are we back on the record, by the way? Okay. We've got the parties present. I believe we're still waiting on one. Oh, let's hold tight before we get started. But Mr. Wood is coming on up and we can hold in place until Mr. Beal returns. All right, I believe we have everyone present now. Mr. Wood has elected to testify, and so Deputy Scott, if you could swear in Mr. Wood.
Testimony should be in the court.
I affirm that it is written that thou shalt bear no false witness.
There, your first and last name.
I will. Full name is Lucian Lincoln Wood Jr. I'll just go with Lynn Wood. How about that?
Whatever you prefer. So, Mr. Wood,
Lynn,
oh, sorry, excuse me.
W-O-D.
And so, Mr. Wood, do you want Mr. Reyes to do a question and answer, or what do you?
I'm going to try to do it the way you suggested, and if it turns out that I'm rambling, or then we'll
I'll
jump
try
in
to
and
redirect you then if you.
let Ibrahim take over.
All right.
So I'll get to that in a minute. So the question, one of the questions, as I understand it, is what is my intent when I post messages on Telegram? I post messages on Telegram. I used to be on Twitter. I got kicked off. Same day he kicked President Trump off. I had built up a following on Parler, got kicked off that too. And then I went to Telegram because Telegram does not restrict the length of your messages. And as the court may see, sometimes my messages are long. I don't know, and I'll find out one day when I see him. But I get up every day and I try to do God's will for my life that day. And I know that God's will for the lives of all of his children, his number one goal for you, is the Great Commission. To share the gospel of Jesus Christ.
I won't do this over and over again, but this is a narrative. It needs to be questioned and answered.
This is my intent. I'm answering.
Well, I think I gave him the option to try it out, and if it's not going to work out, we'll see how it goes. So,
So talking about my intent.
and Mr. Wood, I'll tell you, this is going to eat into your ability to maybe summarize the evidence at the end of this thing. So Just.
Well, I'm entitled to a full and fair hearing.
I agree with you there.
So my number one intent in what I post on Telegram is to share the gospel of Jesus Christ. And sometimes you share things, I'll get someone's attention. Talk a lot about Trump. A lot of people come there because of what I say about President Trump, what I think is going on in this country at the present time. But that's like a lure. Let's go see what Wood said about President Trump. And in the process of doing that, they're going to hear a lot about the gospel of Jesus Christ. Now, it's not me. I can't save anybody. God works through his children. And from what I've seen, I believe that one of the things God does through me, a vessel, is to share his word and bring people to him, or to bring them closer to him. I have been sued all over the country. I can't even go through the states. Georgia, obviously, 4 or 5 times, 6. Maryland, Michigan, Colorado. I think that Wisconsin got me too. I have been subjected to a nonstop flow of lawfare, the use of our legal system, both in civil lawsuits and in bar proceedings, that some would say is an attack only secondary to what Donald Trump has gone through. I know why I'm attacked. Because if you share the gospel of Jesus Christ, if you take up your cross and follow him, you will be persecuted. So I'm persecuted. But that's okay, because I know that my reward for suffering the persecution is in heaven. So I post on Telegram to share him. I post on Telegram to talk about my feelings about issues that are important to this country. That's my right of free speech. I also reprove Freemasonry. Reprove means expose. Every lie will be revealed. That's not Lynn Wood that's going to reveal them. God is going to reveal them, because he knows every lie. So I will take what's happening to me and I will discuss it with the people that follow me. And then I will normally tie it to Scripture so that they can see what's being done to me, how I react to it. And then I tie it to God's Word, because we're supposed to be an example. Now, I'm not perfect. But I do my best to pray every day and ask God to show me his will for my life, and then do it. I hear his voice. His sheep hear his voice. It is written. I don't post on Telegram to hurt anybody that would go against my faith. I do go on Telegram to defend myself. I have that God-given right of self-defense, even when it's used by freedom of speech, another God-given right. Truth if you speak truth, you're going to make somebody mad. Because too many people don't want to face the truth. So I'm sure that in the process of speaking truth, there are going to be some people that don't like me. probably many. Because many will enter through the wide gate to hell, and only a few will enter at the straight gate into heaven. I'm here today because you ordered me to be here, and I've been sued. I respect that you have the position of a judge. You got that position from God. And He will evaluate how you do that mission, pursuant to the Bible or not. I lost all respect for the Georgia bar. I think they're satanic. I think it's all Freemasonry.
Mr. Wood, I want to redirect you from,
Okay.
bar's not a party here. Let's focus on why you are here today. They've raised a lot of posts in these 3 different motions. Anything you want to say about those posts generally or even specifically?
Well, I go through them one at a time if you want me to.
You
But
could.
I'm
worried about all of them.
well, there shouldn't be very many at all. I don't think.
Ask you about a few specific ones.
If you'd like to do that, please do.
So you brought up the one with the Prince logo, and you said that you reposted it, and there was a question of whether that was completely reposted or something you added to. Was that a complete republish?
A complete republication. I didn't add to it. I didn't comment on it.
And would saying that someone's logo, is laced with satanic imagery, would that be disparaging?
It is what it is. I mean, there's a lot of logos and symbols that people are still trying to figure out what they mean. But there's a lot of knowledge now, much more so than there was 4 years ago.
All right. And so
Daryl Powell put it up. I had never seen it. I don't know what the logo means in terms of why Nicole put it up. So he made a fair comment. I republished it. I didn't add to it. I didn't accuse her of satanic worship. I didn't accuse Jonathan Grunberg of being a pedophile. I didn't accuse any of these people of being involved in child sex trafficking. If I knew they were, then I would evaluate whether I should expose it. But I don't have that knowledge. Anything else?
what was the motivation behind posting a picture of his chick?
Informative. Just like when I post, it's like posting a picture without comment. Let people look at it, connect the dots, and draw their own conclusions. Somebody could have looked over and said, well, that's a Girl Scout logo. I don't know. I'd never seen. It's about Prince. It's not, as I understood it, it was the logo of Prince, the singer.
I was talking about the children now, which is what.
You're talking about the children? You're talking about the pictures of Jonathan's children?
Right.
Somebody sent those to me from his public Instagram page. There were other pictures they sent me that I did not post because I thought they were potentially damning to Jonathan. I put those pictures up there because I wanted to know, what does this mean? Why would someone post this type of a picture of his child? I'm trying to figure out why Jonathan Grunberg hates me so much, because he used to love me. Same true with Taylor and Nicole. So for 4+ years since they've been suing me, I struggle with the question of why are these people doing this to me? I was good as gold to. I still am looking to answer that question in my own mind. So I put the picture up. I didn't say a word. And then I evaluate what people thought about it to try to figure out, is there something here I'm missing? Some people, I think, made reference to Freemasonry. I didn't draw that. I didn't draw any conclusion about it. Other than I wouldn't have put a picture of my child up like that myself. But that's my personal opinion. Jonathan felt fine doing it. It's Jonathan's right. Did I answer your question?
All right. Well, I think I understand your position on that one.
I didn't do it to intentionally violate your order.
Okay. And what the YouTube link to a song titled Backstabbers. And you said you could dedicate it to so many people, and among those people include plaintiffs.
Well, I think I mentioned Mike Flynn and Sidney Powell.
Sure.
I said I could include Mike Flynn, Sidney Powell, and WGW, but the list is too long, so I'll just dedicate it to all the children of the devil. The list of people that have loved me and then all of a sudden hate me, it's a long list. But I think I know why. But I said what I said. I don't see how that was an intentional violation of Your Honor's order.
You don't
If you look at my Telegram channel, do you look at it?
what's been in the exhibits? Yeah.
I'd love for you to go look at it when you have time. I post songs all the time. The message is in the song, not the messenger.
What's the message of the song Backstabbers,
That people stab you in the back.
including the plaintiffs?
Anybody that loved me and then stabbed me in the back, draw your own conclusion. Did you draw that conclusion?
Would a conclusion of calling someone a backstabber generally be disparaging, in your opinion?
Not if they're a backstabber, they're a backstabber.
Okay.
I mean, if you look at President Trump, how many people have stabbed him in the back? Almost his entire first administration. And sometimes I feel like that's what's happened to me. That I've been deceived, love you, and then they attack me. That is a standard tactic in CIA psyops. Are you familiar with those?
Well, I don't know if we need to go down that road.
Well, we should at some point, but
Specific post here. So
if that's the worst that I've done, then I apologize. It was not done with the intent to defy your order. If I want to do that, I just do it because I don't care about money. Can't take it with me. I mean, I got to have enough to maintain where I live and the properties that people visit and love the animals in God's creation. But as far as I'm concerned, I go pitch a tent, take my dogs with me. God tells me to do it, I say, yes, sir. Any other issues?
Well, I feel like the more appropriate thing I should do is allow Mr. Beal to have his opportunity to explore this before I try to wade in there as well. So are there any other kind of big points you want to make here today?
Well, I have this from my Telegram channel that Ibrahim sent me, but he's not able to send it where you can see it. So we got it on the screenshot. It was with respect to the post where J.D. Vance was pictured with his wife, and then Jonathan and his wife were next to it. July the 16th. So under the picture of J.D. Vance and his wife and Jonathan and his wife, the next thing I posted was an Instagram message and photo that Jonathan had posted publicly, where he cut off Trump's name on the Trump Tower and said, rump. And then he quoted and said, always knew Trump was an ass. Then I posted something about Nikki Haley, a video clip on the left and her picture on the right. And then I said, I know my enemies in lawfare and why they are my enemies. You have eyes to see and ears to hear. That's from the Bible. Nikki Haley doesn't like me. And I know why. So then next, I posted the picture of Jonathan's child. And then after that, I'd made a general statement, which is true. Give your enemy enough rope and they will eventually hang himself. And then I said, ask Judas. Judas hung himself. And then I started talking about the things that I support and I don't support. My point in making this point is that the plaintiffs are trying to take my post out of context. Oh, we one follow the other, follow the other, follow the other. My posts are not, and sometimes they will be related, just like with respect to when I quote the Bible and then I put in a footnote from the KJV. But that's not always the case. That's an assumption that they're making, and this is a perfect example of where their assumption was wrong. So if in fairness, they want to select and accuse, Your Honor, I can produce, it takes me a few days, but I can produce my Telegram channel for you from its inception. Pretty sure I had to do that for the state bar. I think I can do it for you. I may have to do it for Mr. Beal. And you can look at my posts and put them into proper context. I'm doing the best I can to defend myself against a lot of lawfare and other litigation. I have the right under the First Amendment and under the Gentile decision to defend myself in the court of public opinion. In fact, Gentile says you have a duty to do so. Now, that's a role I play as a lawyer, which is different than what role I play as an individual. So I do use Telegram at times from my lawyer's hat in an effort to defend myself in the court of public opinion. For whatever reason, these individuals started this litigation with some heinous, salacious, irrelevant allegations against me that went all over the nation and the world within a day or two.
All right. So
I
think we covered a lot of that in the
last
hearing
time
we had last
If I can
summer.
take a break and speak to Ibrahim real quick to see if one
All right,
area,
and the focus would be,
just whether I've missed anything in my attempt to do the narrative. I should ask though, did you have any other questions?
I'll see after the cross.
Okay.
Yes. I got you.
Having trouble walking these days. May I proceed?
Yes, sir.
So part of this motion is based on we know some of it is my republication of their photos. It's also based on the republication of Your Honor's video that was public, that Your Honor very carefully discussed with me. And it was clear from the way I read your order, and I won't speak for Sir John and Ibrahim, that I had a right to do that. I didn't comment. It's still up. So you don't have to come to my Telegram page to see it. Your Honor published it, and the public policy of the state is to provide as much information to the public as possible about legal proceedings. So I don't think in any stretch I could be accused of wrongdoing by republishing what Your Honor initially published. There's several accusations where they take my positions on lawfare and claim that I'm disparaging them. I'm talking about lawfare. I'm disparaging lawfare because I think it threatens our legal system and our political process. I tried to be very careful. The last thing I want to do is have you get yanked down here and have me violating your order. I would not do that intentionally. Practiced law for 45 years. Before 2020, my record as a lawyer was impeccable. Never been sued. Never had an ethical complaint filed against me. I still don't have an ethical complaint filed against me by a client. So I had an impeccable record before 2020. Since 2020, I don't think anybody's going to think much of me when they go on Wikipedia. That's designed to destroy me. And I know who's behind it. And I'm not referring to these three people in the courtroom or even Andy Bill. I know who tries to destroy a child of God. So the last thing, Judge, just quickly, trying to think what Ibrahim told me. I think I covered lawfare. I don't think there's any specific accusations against them. And I can tell you, to finish my testimony, whether you believe it or not, whether they believe it or not, whether anybody in this courtroom believes it or not, I love Jesus Christ with all of my heart, soul, mind, and body. He saved me in August of 2018. I'm a new man. And I would never tell a lie about somebody. That's why my channel is Lynn Wood Speaks Truth. I can make a mistake, and when I find out about it, I quickly correct it. But I am not a man that has an intent to harm anybody. If anything, I am a man of God whose intent is to help them find Jesus Christ. Let him use me to save them. And so I talk about hell a lot, and I talk about eternity, because we're going to two places, heaven or hell. That choice he lets us make. But I've studied a lot about hell, and I don't want to see anybody go there, even my worst enemies. And when I write that I love these people, I do. God told me to love everybody, including my enemies. And when I write and say I pray for them by name almost every day.
Mr. Wood, I think we've covered
Okay.
this earlier. Mr. Beal.
Thank you, Your Honor. Real briefly. Hey, Mr. Wood,
Hello, Drew.
I am going to
You can call me
follow
Will.
up on a couple points real quickly. You touched briefly on our prior hearing. Do you remember that hearing on July 7th, 2023?
I remember the hearing, but I don't know that I remember specifics. If you've got something
Okay.
specific to ask me about.
Do you remember when the judge told you not to republish specific pleadings on your channel if they contain disparaging comments about the plaintiff, and that to do so would constitute a direct violation of his order?
That's not what he said.
Okay.
What I understood him to say is that if I went out
Objection.
and let me answer.
Well, Mr. Beal, I will say, the best I can recall from the transcript is I thought I might have been a bit muddled on this point. I don't know if I was all that clear.
Okay.
You can try to establish it, but I don't know if I.
But what I understood was that if I went out and created a pleading to disparage them or that disparaged them, and then I pointed people to the docket to see it, that would have been a violation of your order.
Let's see what the judge actually said. You can read along with me right here.
I'll look at it. Let me take a look.
Well, you can read along with me. So let's put it right here in front of you.
Let me see. I can't see with your hand on it.
Well, you're going to have to look at it right there because we're going to look at it together. But I think we might find
Could you step?
ourselves.
Would you mind stepping back a little bit?
Okay.
You're loud. Let me read this.
You have two copies, perhaps, Mr.
No, I don't.
Beal? Oh, all right. Well, how about you read it aloud, and then you can hand it to him, and he can confirm whether you read that correctly.
Thank you.
Hold on.
How about
It says,
we do what the
now you
judge
can
said?
provide truthful information about the lawsuit, including,
He's going to get
Thank
you
you.
read it first, and then he'll hand it to you, and
All
then we'll go like that.
But I think we might find ourselves right back here and with an automatic $15,000 penalty if we are publishing the docket. Because to me, that goes against the terms of the injunction. I'm on page 147, starting on line 7. Mr. Wood, the public docket is public record. The court, it is, Mr. Wood. Now, it's not sealed. The court, it is, and so anyone you want in the world can go in there and look at it. Mr. Wood, yeah, I just don't publish anything from it. They can go look at it themselves. The court, that's right. Mr. Wood, if you want to know information about the case, go look at the docket. That's not going to get me in trouble, is it? The court, sure. But you say, go look at this exact pleading I just filed that says all these things that disparage the plaintiffs. then we're in trickier waters. Page 148. Mr. Wood, I'm not going to get into trickier water. I just want this case over with. That's why I'm anxious to get a ruling on the motion to dismiss the fraud.
And
Now-
so, Mr. Beal, I'll just say, I read that back to me and it's painfully ambiguous in my mind. I think I'm waffling and not giving him a clear order of, don't do this, don't do that. And I mean, I don't know.
And let me just say this, Judge. He left out the part where you said, now you can provide truthful information about the lawsuit, including hearings, pleadings, trials, depositions, and discovery proceedings. So anything that's on the record is fair game. What I understood, and I thought about it because when I saw this, I said, what did I do? I thought Your Honor was saying if you go out and create a pleading that disparages these people, and then you specifically point the public to it, that's going to violate my order. I have not done that.
All right, Mr. Beal, any just general argument or follow-up you want to make on that? I'd just...
So the entire first hearing, you immediately after this, published on your channel, the YouTube link.
Yeah.
So that all your viewers could see all of your comments that WGW were liars and they proceeded with a groundless lawsuit and they were extortionists.
I don't even know what you're
using their
talking
own
about.
words.
You're saying something that's hearsay. I don't know what people said. I don't remember what they said it after I posted it, but who cares? It's free speech. The court, I think, clearly allowed me under his statement to publish court proceedings. And then if people want to comment on it, they can comment on it. And I put the whole thing out there. They could have listened. They could have looked at it and gone, Wood's a dog. Because they heard all things y'all said about me.
It would be fair to say that all of your statements here today, especially about your faith, are statements that you've made in truth and from your heart.
Absolutely.
Okay. And that all of your statements, like when you're online and you talk about your faith and things that you're publishing on the Telegram channel, they're from your heart.
Well, when you say things I publish on the Telegram channel, that's,
Statements that you made on
can I finish?
Telegram
May I finish?
Are truthful and they are from your heart.
Now, listen carefully.
Can you say yes or no and then
I'm going to answer the question and you won't give me a chance to answer it. Drew?
Yes or no first, Your Honor.
But I have the right to explain.
If you can answer the
I think that mischaracterizes what I say.
So my
Now,
question is, you say yes or no, or I don't know.
yes,
You can explain.
I can say yes. I believe that what I say on Telegram factually is true. Every statement I make, I wouldn't sit here and go, it's from my heart. I would say that any statement I publish on Telegram about my faith and about the Holy Bible and Jesus Christ, that comes from my heart.
And you believe it's kind of your duty to call out parts of our society that you don't like or that you think are wrong or bad. Let's take out you don't like and just say things that you think are evil or wrong or bad. Is that correct?
It is written.
Yes or no, and then you can explain.
I can't answer that question, yes or no. Let me answer it.
Yes or no.
No, well, you may need it, but I don't.
if he says there's no yes or no answer to it, then I don't.
What I will say to you is,
Withdraw the question if you can't
All right.
answer.
Okay.
well, I can answer it if you give me a chance. May I answer the question, Judge?
Mr. Wood is withdrawing the question.
Would it be fair to say that your statements made on Telegram, as the statements made here in this court, are intentional?
I think everything somebody says is intentional. Doesn't mean it's always perfect. We're all imperfect, Drew.
And when you referred to WGW as backstabbers, that was because you feel that they no longer like you or no longer love you.
That's not true.
That why they're backstabbers?
That's not true. I actually think they still love me.
Okay. And then you also put in the category of backstabbers, the State Bar Association.
You bet. Yeah, the State Bar Association.
And
I did put them in there.
Most of the bar of the state of Georgia would be in that category, right? Turning their back on you.
No, I wouldn't say that the State Bar of Georgia turned its back on me. I would say that given the number of years I practiced law here and the relationships I developed with a number of lawyers all over the state, in fact, all over the country, I was disappointed that they didn't stand up and fight for me.
And you think it's your duty to intentionally call out these people for what they've done wrong. Is that true?
It is my duty.
Yes or no? And then you can explain.
I can't answer yes or no.
Yeah, well, it's
No.
either a yes or a no.
Why don't you just
call
let me answer the question?
No.
Well, if
No
you can listen, you
cross-examination.
can listen to the question and answer only the question asked if you can, Mr. Wood. And
All right, restate the question.
And you believe it is your duty to call out these people who have done things wrong or bad that you see with your eyes. Is that right?
I don't make the decision of
Yes or no?
the way you frame that. The answer is no.
Okay.
It's not a duty. May I explain now?
you can explain.
It's not a duty. It is written by Apostle Paul that if you see evil, you are to reprove it. That's what God in His Word tells us to do. And I do my best to obey God. That's the way I would put it.
So you're following God's law.
I'm following Jesus Christ.
And by doing so,
He'll determine if I did my duty correctly or not. I think He saved me, so I don't know how many rewards I'll get in heaven, but time will tell because I'll be there.
and you also you believe that these three have engaged in lawfare against you because there are multiple lawsuits that they have filed, and you've referred to them multiple times in your posts as having engaged in lawfare against you.
I don't specifically mention them. I talk about lawfare in general, which has been waged ferociously against me for almost 5 years.
When you refer to the Atlanta tribunals and the lawfare and my former partners, are you referring to maybe this court and those people who used to be your partners?
I don't think I limited to them in the way you're saying it. Listen,
But when that's who you're referring.
I hope you read my Telegram channel because there'll be a lot of scripture in there that I would hope you read. You will be called before the tribunals. Jesus tells us that. They will drag you before the tribunals. They crucified Him. They don't allow crucifixion now. But they hated Him. They'll hate me because they hated Him first. So the persecution that Jesus suffered was the worst death in the history of mankind.
Mr. Wood, I understand your answer. Mr. Beal, you can ask your next question.
Hold on for me 1 second, Your Honor. You see that on the screen in front of you, Mr. Wood?
Is there a date on it? May 24th, 2023.
So when you said I am being called
Please let me,
before the
please.
tribunal next
Mr. Wood, you
week
can let him ask
on-
his question a few more times. You don't have to answer right away. So if you want to ask your question, Mr. Bill, you can ask your question.
Thank you. I'm being called before the tribunal next week on June 1st in Fulton Superior Court in Atlanta in one of the civil lawfare cases filed against me. I'm going to speculate here, but I think you're talking about this court and these three people. Is that fair?
I think it was June the 1st, and I used the phrase, I'm being called before the tribunal. This is a tribunal.
And this is the lawfare you're talking about, is that
No,
fair?
the lawfare I'm talking about is lawfare in general that is being waged by individuals utilizing the court system for their own political purposes, usually to attack their political opponents. And I'm not through answering. And I believe that that is a form of spiritual warfare. We do not wrestle against flesh and blood, Drew. Ephesians 6.
And you threw in Fulton County Superior Court just for the fun of it. You weren't actually referring to this court and these three individuals.
I disagree with what you just said.
Okay.
I didn't do anything for the fun
Would
of
it
it.
be fair to say that you've made a big part of your living, your entire 45 years, 44 years of practicing law, by making a connection between a disparaging statement made over here and a reference to an innocent plaintiff over there, the way you did in the John Benet Ramsey cases?
That was not,
Mr. Beal, I don't know if we want to go open up that can of worms. We're going to really litigate like the entire John Benet Ramsey defamation case. Can we
Just the notion that he's not referring to WGW when he skips a line in the
let's
post.
avoid any reference to some other case.
I spent about half my practice starting with the Richard Jewell case in 1996, focusing on defamation and damages to reputation. Before that, it was primarily medical malpractice for the plaintiff. So I understand what of and concerning means, but it has to be direct. You can't come up with it by connecting a bunch of different dots and going, oh, they were talking about Richard. No, they got to say it, just like if I'm accused of disparaging someone, which is different than defamation. You got to say it. You can't go out there and try to connect a bunch of dots and say, aha, I see you put all this together and you see what all these people said about it on the reply channel, and it magically becomes disparagement. That's just not the way it works. Just like what did Jonathan disparage himself when he published the pictures?
See if we can connect the dots right here on this. I got hit with more lawfare today. The court in the original WGW case set a hearing on June 1st to determine whether I should be held in contempt of court for exercising my right of free speech to defend myself. So it's pretty clear there that warfare equals lawfare equals this court and these three plaintiffs, right?
No, I've told you what lawfare means. This was before Your Honor's order. This was talking about when I was going to appear. You had not entered an order, so you can't use this statement to say that I somehow violated Your Honor's order that came subsequent in time.
Well, you're getting to his ultimate point. That's not the question he's asking. He's asking
Well,
about law firm.
the ultimate point is, do I feel like all of the law?
I agree, Mr. Wood. Let's
Maybe
to the
even
questions that are asked.
Okay. Let's just skip ahead to the republication of the picture of Jonathan's children at bath time. And you felt it was your duty to republish that picture and follow it with a description of your hatred of pedophilia.
That's not what I did. And no, I disagree with your first statement. And I don't know, I think the statement you're referring to was the list of the things that I opposed. Pedophilia is one of them. I think pedophilia and child sex trafficking is the real pandemic in this country. Somebody's got to speak up for the children. That post was not related to Jonathan Grunberg's picture.
A pedophile?
Well, not. I don't have any information that says he is. And that's why I thought it was errant nonsense when you sent that thing to the court claiming I branded him as a pedophile.
Because there was absolutely no reason for you to publish a picture of his children at bath time, followed by your description of hating child traffickers and pedophilia.
I listed all of the things that I stand for and against. It's no secret if people follow me, they know that I stand against pedophilia and human trafficking, that I support President Trump, that I love Jesus Christ. I dislike the pharmaceutical industry. I dislike the FBI and the CIA. I mean, I put an honest list in here. It was not, you're trying to, you're so rude to me. I'm not talking in code. I'm a straight talker. I know who talks in code.
And so
Traveling man.
Jonathan's children had to be published by you because
No.
of something that you saw or thought.
Are you done?
I'd say yes or no.
No. I've told you why I published it, and you're wrong. I don't suspect Jonathan published it to do that. He published it first. I didn't say anything else about it. Why did he publish it? Do you know?
Mr. Wood, I think I have some follow-up for you. On
Okay.
page 18 of plaintiff's emergency motion, there's a screenshot of what appears to be a text message. Does this ring a bell to you at all? It says, and the text message reads, it's from someone named Lynn. I hit him this morning in a manner that did not directly disparage him or violate gag order. Does that ring a bell?
I saw that, and it does not ring a bell, but I know that I think that's, I don't know who posted that. I may have put it up, but I've looked at it and I tried to figure out what was I talking about. Then they're trying to insinuate that I was talking about Jonathan. I don't believe that's
Bottom line,
true at
you
all.
don't recall sending this text message or to who or when?
I don't recall it, but I know that I've often said that I hit people hard when I quote the Word of God, the Holy Bible. It is a sword.
So a sword typically being referred to as an offensive weapon.
Under the full armor of God, the Word of God is the only offensive weapon. The rest are defensive.
All right. So generally when you refer to someone as hitting them, that's not.
I don't know the context of who I was talking to and what I meant. There's no way there's no way for me to know that based on that one excerpt. It has no context.
We don't know when it was posted either.
Ron, this is from Ms. Wade's affidavit.
I don't recall an affidavit on the emergency motion for contempt, or at least there wasn't one tendered.
It's from July of 2023 is what it is.
Okay.
Is there a bigger context?
We can leave it at that.
You remember saying, I am still under a gag order, very strange, in the case Jonathan Grunberg et al. Filed against me. I think I now know what was behind the frivolous lawsuit. He has been used to attack me in Mother Jones, AJC, and soon New York Times. Jonathan is a communist. So is Ed Buckley, who represents him.
Well, you told me it was.
Sure would be interesting if someone tweeted.
Okay, I don't need to read it. I'm looking right at it.
And what date is
this? Bottom line,
What year is this?
that's what I'm getting at. This predates our original hearing last summer. Is that what I'm seeing in the context here?
Yes, Your Honor.
Okay, then that really kind of answers any relevance I had for it. I didn't know if this was part of this subject matter. I understand the larger point you're trying to make with it. I don't think it really draws into what I was after. All right. Thank you, Mr. Wood. You can step down.
Thank you. Short,
And
short break,
Well, let me just ask if you have any further evidence to present.
short break. I need to
Mr. Reyes or personal comment?
talk to Mr. Reyes and John.
All right. I'll give you a few minutes here.
Thank you.
Yeah. She was on that.
Back on the record?
I don't know if we ever went off, but were you, I'll take your time and let me know your announcement.
We don't have any further evidence. Your Honor, we rely on, obviously, our pleadings that we filed and responses. Mr. Reyes, like to make a few comments in closing.
I understand. And I want to, let me first just make sure the record is clear. Is there any rebuttal the plaintiffs are seeking to introduce as a result of the evidence presented by the defense?
No, Your Honor.
All right. So at this point, we'll consider the evidence closed because the kind of the foundation that this motion is brought upon is on plaintiffs 1 through 3, and those are all conditionally admitted. I don't think that's something I can rule on today because the record's not complete. And so until they've had a chance to look at the redactions and look at them, we can't really, I can't really make a ruling because they may have objections to your redactions. So to that same end, I think I promised both parties the ability to kind of make summary statements, although I have a pretty good feeling of what the arguments are on both sides. And so to that end, my inclination here is that we're going to have to find a time. I would say that it's going to be over Zoom, where we reconvene and I get allow both parties to make whatever closing thoughts they have. I'll probably set a time limit. And we can find a date where that works for everybody. I know schedules are complicated here. And Mr. Beal, you're jumping, you're ready to jump up. What do you want to add?
Have 1, 2, and 3 completed. Everybody can
I
look
know.
at it real quickly right now. If they want to.
I know, but that still wouldn't give us time to really flesh out what I anticipate there would be in closings. And there's something else. The reason I want to bring you back as well for some arguments is there's something I want you all to have some time to dwell on and brief if you want to for me. But I'd also be willing just to hear oral argument, which is, again, without having ruled on any of the particular posts, I think it's likely at least one of, if not more of these, are going to be in violation of the order. I think that Mr. Wood's testimony that he didn't intend to violate the order isn't, from my understanding, and I'll take a closer look before arguments, isn't so much the intent that's relevant. It's the intent of whether he posted these acts and their ultimate interpretation of them. In a similar way, even if I say I didn't intend to violate the law, you can still be found guilty of a criminal offense because that's the proper intent that we apply. I'll let y'all take that up at closing if I've got that wrong.
I want to brief that.
Look, I'm going to give you full opportunity to take that up at closing. Here's what I'm getting at. My point being is that because it does look like these, again, Mr. Wood's relying on, First Amendment grounds that I think were covered by the Court of Appeals and addressed at our hearing last summer. Where I'm at is using the authority the court's given to revisit prior civil orders. And specifically, I'm looking back at the order that started all this, which is the October 2020 injunction order. And so I would want what I'm asking the parties to look into and let me know what they think their position on the law is whether the injunction order should be amended simply to say, instead of disparaging comments, that during the pendency of this lawsuit, Mr. Wood shouldn't be mentioning the plaintiffs at all.
That would be a total gag order.
Against the plaintiffs. That's right. And so I'm willing to hear, and I would amend that to being essentially issuing, publishing, or making statements, images, or comments about the plaintiffs through social media. And simply because I think it may be warranted by where we are at this point. And so I'd like to hear either briefing or oral argument on that.
If you'll give us some time.
That's what I offered. And so
I got
you got things to deal with. And so I would let the parties confer and tell me what date they want to come back just for argument on this motion for contempt. For a final, before that point, I'm going to be asking if there are objections to plaintiffs 1 through 3. And then I'd also like to hear positions on whether this preliminary injunction should be amended. Any housekeeping issues or reactions to that for today? Let me start with the plaintiffs.
Thank you.
It's good faith effort. It's
Not one.
It's not an effort. It's not an intent.
So I think the judge will let us brief that John has said the question is whether there was a good faith effort to follow the order.
And I'm going to emphasize here that haven't made any finding about what intent is here whatsoever. I'm kind of exploring that as even if I accept your arguments on their face, whether that's even good enough. That's what I'd like to explore, and we'll see. I'm still reserving the issue of whether I think you intentionally violated the order. All right. So
we'll have time to brief that issue in this.
If you want to brief it or close it or summarize it.
No, I'd have to go back and look at the law because I'm not familiar with a gag order in a civil case. You've taken me from an anti-disparagement. Now they're trying to say defamation. Now you've taken me to a complete gag order potentially, and I've never heard of that in a civil case.
And that's what I'd like to find out.
Okay. Just give us time to do it, Judge. I
understand. And so I'll let the parties confer and let me know what a date they would propose. I also want to ask I know that we've now reached, I think according to the special master's latest ruling, the discovery period is closed. I think dueling, MSJs have been filed. And I don't recall offhand, was oral argument requested on those, or were these supposed to be submitted on the pleadings? Does anyone know offhand?
Specifically requested, Your Honor.
Okay.
We would like oral argument.
Well, if it's going to have to be in compliance with the uniform rules, if that's what you want. So I don't know whether that request had to have been made contemporaneously or not. I'll defer to the record on that, and we'll go from there. But bottom line is, after we've made a decision here. We're moving on to figuring out what's going on with these motions for summary judgment. Is that right?
There is one issue that Mr. Exum has raised.
Okay.
That's a potential filing of a motion for reconsideration on the question of opening up the discovery just so we can get a copy of the settlement agreement with Mr. McMurtry. And he didn't reference a reply brief that we filed, but he was very particular in referencing what he had read. And so that issue's.
Has he filed that, or have you filed that already?
No, I have not filed it yet.
Okay.
But I let the court know I was doing it.
We'll keep an eye out for it. All right. Thank you all.
Thank
We're in
you, Your Honor.
recess.
Appreciate your time.